Definition of contract of sale and formation, 10 marks. Sale of Goods Act, 1930. Introduction. The Sale of Goods Act, 1930 governs contracts relating to the sale of movable goods in India. A contract of sale plays a vital role in commercial transactions by regulating the transfer of ownership of goods from seller to buyer for a price. Definition of contract of sale, Section 4. According to Section 4 of the Sale of Goods Act, 1930, a contract of sale is a contract whereby the seller transfers or agrees to transfer the ownership of goods to the buyer for a price. A contract of sale may be: sale, ownership passes immediately, or agreement to sell, ownership passes at a future time or subject to conditions. Example: selling a mobile phone and delivering it immediately for 20,000 Indian rupees is a sale. Formation of contract of sale. A contract of sale is formed when the essential elements of a valid contract are present. The formation includes the following stages. 1. Offer. The seller makes an offer to sell goods at a certain price. 2. Acceptance. The buyer accepts the offer unconditionally. 3. Consideration, price. There must be a price paid or promised in money. 4. Goods. The subject matter must be movable goods. 5. Transfer of ownership. The seller must transfer or agree to transfer ownership of goods to the buyer. 6. Mode of formation. A contract of sale may be oral, written, implied by conduct. Example: purchasing goods from a shop and paying at the billing counter. Case study. Case: Levy-Griffin, 1861. A dentist agreed to supply artificial teeth for money. Held: it was a contract of sale since goods were transferred for a price. Conclusion: a contract of sale is a legally binding agreement that ensures smooth commercial dealings. Proper formation of the contract provides certainty regarding ownership, price, and rights of the parties under the Sale of Goods Act, 1930. Essentials of a contract of sale, 10 marks. Sale of Goods Act, 1930. Introduction. A contract of sale is the foundation of commercial transactions involving movable goods. To be valid and enforceable under the Sale of Goods Act, 1930, a contract of sale must satisfy certain essential elements. These essentials ensure legality, clarity, and protection of the rights of both buyer and seller. Essentials of a contract of sale. 1. Two parties, buyer and seller. There must be two distinct parties. Seller, who transfers or agrees to transfer ownership. Buyer, who purchases the goods. A person cannot be both buyer and seller. Example: a shopkeeper selling goods to a customer. 2. Goods. The subject matter must be movable goods. Money and immovable property are excluded. Example: sale of furniture, books, or vehicles. 3. Price. Price is the monetary consideration for the sale of goods. It must be paid or promised in money. Example: selling a laptop for 40,000 Indian rupees. 4. Transfer of ownership. Ownership in goods must be transferred or agreed to be transferred from seller to buyer. Immediate transfer rightward arrow sale. Future transfer rightward arrow agreement to sell. 5. Valid contract. The contract must satisfy all essentials of a valid contract under the Indian Contract Act, 1872, such as free consent, lawful object, competent parties. 6. Include sale and agreement to sell. A contract of sale includes both sale, agreement to sell. Case study. Case: Levy-Griffin, 1861. A dentist agreed to supply artificial teeth for money. Held: it was a contract of sale since goods were transferred for a price. Conclusion: the essentials of the contract of sale ensure that the agreement is lawful, clear, and enforceable. By fulfilling these conditions, the Sale of Goods Act, 1930 provides certainty and security in business transactions involving movable goods. Basis of difference. Condition. Warranty. 1. Meaning. A condition is a stipulation essential to the main purpose of the contract. A warranty is a stipulation collateral to the main purpose of the contract. 2. Importance. It goes to the root of the contract. It is subsidiary to the contract. 3. Nature. Fundamental term of the contract. Secondary term of the contract. 4. Effect of breach. Breach gives the right to repudiate the contract. Breach does not give the right to repudiate the contract. 5. Right of buyer. Buyer can reject the goods. Buyer must accept the goods. 6. Remedy available. Buyer can reject goods and claim damages. Buyer can only claim damages. 7. Impact on contract. Contract may be terminated. Contract continues. 8. Legal consequence. Treated as serious breach. Treated as minor breach. 9. Conversion. A condition may be treated as a warranty. Warranty cannot become a condition. 10. Example. Car must be brand new, defect allows rejection. Reservicing promise, breach allows damages only.